Thank you very much, everyone, for joining us this morning. My name is Nigel Gooding. I had an apology to make, which is quite disappointing. I can see that the subtext, this actually said Nicole Gooding, so that's always a very good start. But I'm definitely Nigel Gooding. Natalie Bennett, who is our senior consultant here at DPAS, should be with us, but unfortunately, due to sickness, Natalie can't be with us. But I'm absolutely delighted to be joined by Kunbi today. So, Kunbi, are you there?
Yes, I am, Nigel. Good morning.
Thank you very much. Thank you very much for stepping in at the last minute. So I'm really actually pleased that you're able to do so. So just to give you a bit of background to me, for those people who don't know, I founded DPAS Data Privacy Advisory Service some 5-6 years ago. And as a result of that, we've grown into an organization which not only provides support for data strategy, data compliance through a range of activities, subject access request support being one, and also training as well, particularly around the BCS Data Protection Practitioner Foundation courses and specialist courses around subject access requests and other areas of data protection law management. One of the things that I was conscious of doing was trying to give support to the broader practitioner community and providing them with practical advice about how they might adopt some practices towards some of the challenges that they face in their day-to-day job. I'm also very dull academic when it comes to data protection and information rights law. I hold a master's in laws degree from Northumbria University in information rights law and practice, and in particular my dissertation was on subject access requests. And I will share that paper with you later to give you some context. It's a useful context paper around how the right to subject access requests developed. So that's me. I'll be sharing this, and it'll be a sort of double act between myself and Kunbi. Kunbi, who are you, and what's your role here at DPAS?
Thank you very much, Nigel. My name is Kunbi. I work as a data privacy officer here at DPAS, and I just finished my master's in commercial law at the University of Exeter. So my work at DPAS is focused primarily on international data transfers, but also on subject access requests and data protection audits as well. Thank you.
Thank you very much, Kunbi. That's absolutely great. So if we could move to the next slide, Emma, that would be super. I think we need to set some context, and in the chat box, I provided you a link with the dissertation, the 17,000 words I wrote on subject access requests, and certainly the context piece is actually quite interesting about how we got here. Subject access requests has been, and the right to has existed since 1984. The 1984 Data Protection Act, Section 21, gave the right to us as data subjects to request information related to what data is held by, at the time, data users. They were called data users, they're now called data controllers. So Section 21 was the first enabling act of Parliament to give us the right. That was enshrined again in the 1998 Act under Section 7 of the Data Protection Act 1998. And once again, it was a very similar piece of legislation that we see now in Article 15 GDPR stroke UK GDPR. So the right has been around a long time, driven by the right of the 1981 European Council Convention 108. The right has been really in practice since 1984. The right in 1984 was quite interesting because it was only on automated computer-generated data. It wasn't on manual data. And when you think about the business landscape in 1984, there weren't an awful lot of us who had computers, particularly computers that were linked to each other as well. So the right only existed for information that was generated by a computer machine. But over the period of time between 1984 and 1998, we saw the Access to Medical Reports Act in 1988, and 1990 the Access to Medical Records Act in 1990 allowed us access to manual paper-based records. So over a period of the last 30, 40 years, we have seen this right enshrined in law. And there have been various court cases, Durrant being the seminal first case, There have been a number of court cases which has driven the guidance from the Information Commissioner, put some meat to the bones for the intention of the lawmakers in the right, and tried to put some logical guidelines really for us as practitioners. I think the first thing I'd like to say in the context piece is that the right to subject access and the right to access information which relates to us, which is about us, is not an absolute right. So it's not an absolute right in all circumstances of which you can have access to information that relates to us, relates to you. And Schedule 2 and 3 in the Data Protection Act 2018 lists a number of exemptions which exist, which Kunbi will be touching on a little later. The starting point, I think, that I always like to say when we talk about subject access requests is how can you give us top tips? What are the top tips, Nigel? What's the best tip that you could give us from this exercise, from your experience? Well, my best experience is to have a policy. The best policies that I've seen are a policy which outlines and is transparent quite clearly, not only to the organization that you work for, but also transparent to those people who request information of you. Invariably, 95% of information and personal data that you hold about an individual is contained in your core computer systems. So let's take a HR record, for an example. It might be in something called iTrent. iTrent might hold all your personal data related to an employee. You might hold one manual record on an individual, and that's locked in a filing cabinet. And those two are the only areas whereby actually the vast majority of personal data is held. Now, personal data may be held in emails, but the vast majority of your personal data will be held in systems. And a policy that defines which systems that you will search on, which systems will you make your reasonable proportionate search, right up front gives not only your organization some surety and some confidence that you will not be spending hours spending lots of resources and time and money searching through various systems. It also tells the data subject that you think that this reasonable proportionate search relates to only these core systems. So I think the policy is a great starting point, and there's some great templates online for a policy. So if you don't have an organizational policy about, one, how the organization should respond to a subject access request, and two, what the expectations are, manage the expectations of the individual who is applying for the subject access request. I think that that's most probably the starting point that you might want to look at. And one of the interesting things as well that we think about the context of subject access request is that there has been some recent muscular action by the Information Commissioner. Kunbi, you mentioned this morning about 7 organizations who have been picked up the backside by the Information Commissioner. What's that all about?
Yes, so in that instance, the Information Commissioner's Office they issued an enforcement notice against 7 organizations that have been found to consistently be either delaying in their response to SARs, subject access requests, or addressing them in a manner that the ICO considered to be inappropriate in terms of not providing the necessary information or some other violations. So the organizations involved, they range from very large organizations like the Home Office, the Ministry of Defense, 3 London boroughs, Croydon, Lambeth, and one other, Virgin Media, which is a private organization. So it just shows that the ICO has recently taken a more aggressive stance toward compliance with subject access request regulations. In fact, in their strategy document, which they released, talking about how they intend to enforce information governance laws between now and 2025, compliance with subject access requests was a priority for them. So I think we can expect to see more of those kinds of instances going forward.
Thanks, Kunbi. And it's dead right. Ultimately, if you are delaying someone's fundamental right, which is enshrined by law, then therefore you can expect some muscular action from the Information Commissioner. So hopefully we'll give you some tips today and some advice today how you may wish to avoid that. and also some things that you can take away back to your organizations that you'll find pretty useful today. We always say that in DPAS that learning must add value to the learner's experience when they leave the seminar, when they leave the teaching session, when they leave the webinar. So hopefully today we will add value to your learning experience about subject access requests. Please do not be scared to ask any questions whatsoever. We've got the chat box going. I will manage the chat box going, and Kunbi is going to take us through the majority of it with Nigel's usual interjection and maybe challenges back to Kunbi. So Kunbi, all yours. The floor is yours for the time being. Thank you very much, Nigel. So now we're talking about Article 15. Article 15 of the GDPR and the UK GDPR, entitles data subjects, people generally, to put in a request for their data. And I think that's key because a lot of times we gloss over the fact that a subject access request is exactly what it says, is a subject access request to that person's personal data. Anything else is excluded by default, right? So the person is entitled, as we have listed here in these slides, to first a confirmation that the organization is processing their personal data, because obviously if you're not processing their personal data at that time, your responsibility is merely to tell them that no, we do not process your personal data, therefore we do not have your personal data under our control. Thank you very much. The second obligation is to provide that person with a copy of their personal data. And you'll see in bracket there, we have not documents. That's because a common misconception that we've seen happen and that resulted in very drastic consequences is when organizations default to releasing the documents which contain a data subject's personal data. And that's very problematic because it's very likely that those documents would include information that does not relate to that person and potential information that relates to other people, which is a major problem, which we're going to address in detail when we're talking about guidance for actually redacting documents and excluding certain information that does not relate to the personal data of that individual. Now, just to be clear, the point is not that you might not have to provide documents. The point is not to default to providing documents in response to a subject access request. So you might need to provide a document if the entirety of that document contains the person's personal data exclusively. But the point is, if that is not what is the case, you should, per the ICO's guidance, be redacting everything else in that document and only providing the bits that relate to that person. In fact, in certain instances, it might be possible to not provide the document at all and just provide the snippet, maybe in an Excel document or a Word document that relates to the person, and then giving the person context to say, oh, your name appears, in 200 class attendance lists between the 1st of January 2022 and the 19th of October 2022. But instead of giving you every single one of those lists with everything else blacked out except your name, we're going to notify you that your name appears in this list of documents, but this is what exactly it says, just your name. And that suffices per the ICO's guidance. So the point is that not to default in either direction, but to treat each case on its own merits. Now, in addition to Kunbi, it's a really interesting really interesting point, and I've got a note from Adrian there. Look, the key statement in the ICO's guidance at the moment is if it relates to an individual. Does that relates to an individual? One of the challenges you have with subject access requests is actually, let's go back to Durrant. So Durrant was the seminal case, the background to Durrant, and it has been amended since then, the court judgment, I will grant you that. But let's go back to the seminal case. Durrant had made a complaint about Barclays Bank. Barclays, he'd made it to the Financial Services Authority. The Financial Services Authority then decided to investigate Barclays Bank, and then Durrant put a subject access question, wanting to find out about the investigation. Cutting a very long story short, Lord Justice Auld, who was sitting in the Court of Appeal, said that actually the whole issue was about an investigation into an organisation, and actually the Lord Justice Auld said Mere mention of the data subject in a document held by the data controller does not necessarily amount to his personal data, because it's about an investigation that is taking place. It was just merely because of the fact that Old complained that his name was mentioned in the document, so therefore he couldn't have access. But Old did say, and which has been reflected in the current guidance that sits within the Information Commissioner's guidance, going on to say that a dependence being a continuum of relevance or proximity to the data subject. So Adrian, if the information, if the subject matter is about Adrian or Nigel or Kunbi, then there is a continuum of relevance or proximity. But if, for example, it is an email which merely relates to that Nigel, Adrian or Kunbi attended a meeting, then therefore I would say actually, and it wasn't necessarily about us, it didn't necessarily relate to us, it had no continuum of relevance or proximity to us, the meeting was about, for example, the Christmas party, then I would suggest that actually that would not meet the threshold for personal data.
Exactly that, Nigel, because again, like I said, it's entirely focused on giving the person their personal data. So what Nigel is saying, Adrian, is you do have to state where the data came from if that context is something that relates to the data subject themselves. But if it doesn't, then no, you do not have to state where the data came from. As a matter of fact, you do not necessarily have to provide the information in that particular context if there's absolutely nothing else where that ties that individual to the subject matter in question. So there would not be a question of context in such an instance. Now, in addition to the person's personal data, the GDPR requires that you provide supplementary information, and that supplementary information is what often you might refer to as metadata. It refers to notifying the person as to, first, the purposes for which you're processing their personal data, the kinds of personal data you process, just an overview of that, since they are going to be able to get the full information in the actual data that you provide. Also notify the person who the recipients are of that data that you have transferred the data to, especially if there are any international transfers involved, and also to notify the person of the right to complain to the ICO if they have a dispute with how you've handled the subject access request they've put in. Automated decision making is crucial as well. You're required to notify if you've undertaken any automated decision making process as part of your processing of that personal data. Can we have the next slides, please? Now, with regard to the considerations that you should, have in mind when you're addressing any subject access request, the first one, and we have a very nifty chart we're going to show subsequently, but as an overview, the first thing to do is to prepare and assess the subject access request as a first step to complying with it. So that's going to be validating the identity of the person who has asked for that personal data, to be sure you're providing personal data to persons who are entitled to receive it in the first place. The second one is identifying what the scope is, and this might involve engaging with the requester. The third one is to actually conduct the search, and this is where we found that a lot of organizations have problems with because of a lack of predetermined processes that all members of staff are aware of in terms of how they will be able to find the information that has been requested in a subject access request. The third one is identifying all components of the search results that are not personal data and removing them in order to ensure that only personal data is contained in the data set you are going to release, subject to eliminating other information that are covered by exemptions, which we're going to cover in more detail as well under the Redaction Guidance section. And the last one is the THEC, and this covers first what format to release the data in. The general rule is that you release the data in the same format in which the request was made, which in most instances will be electronically via email or a contact form or something along those lines. And also it covers the software that you might use to manage the process from end to end to be sure that you are complying and avoiding any sort of scrutiny from the ICO. Can we have the next slide, please, Emma? Personal data, it's important to be clear on exactly what it means. Now, this is the definition of personal data in the GDPR, and it's essentially any information that relates to a living person. I mean, in summary, you can see the full definition there. And in practice, what this means is that it applies to information that was supplied to you by that individual. Yes, that's pretty obvious. If the person has supplied information about their name, their address, their employment, academic history, and so on and so forth as part of an employment, for instance, that information is in scope. But it also applies to information that has been created by your organization or another organization on your behalf using the information that person provided. So if you had done some assessment, if you had done some sort of automated decision-making, for instance, again, you have an obligation to provide that data to the person because it's in scope based on the fact that it is information that relates to an individual. And this also includes opinions, right? This is often an area of some tension because many organizations and many members of staff of organizations are not aware of the fact that opinions or statements that are made on a subjective basis are also in scope, depending on if any other exemptions apply to them. But mainly because it was an opinion or a subjective assessment made by someone else, doesn't mean that it's out of scope, because some people tend to think that is automatically third-party personal data. It's not. The only obligation you'd have then is to redact, where applicable, the information of any third parties. But the fact that the organization has in its custody opinion, subjective assessments of any sort that relate to that individual means that that information is that person's personal data, which they will be entitled to. So in practice, we've seen this commonly with things like, assessments that are in HR files, for instance, complaints, procedures, interview notes, and so on and so forth. So here's where what Nigel said at the beginning is also very crucial with regard to how it's important to have policies in place that determine how you manage any subject access request you receive. But it's also important, and this is something that we take as a priority here at DPAS by ourselves and also on behalf of clients, in terms of ensuring that you are not accumulating personal data unless it is absolutely necessary. Now, this ties in with the principle of data minimization in Article 5 of the GDPR, but from a more practical standpoint, it's also important because you are then reducing your exposure, because you would not be under an obligation to release any personal data that you do not have, right? So there's absolutely no reason, for instance, to keep, interview notes for 20 years, for 30 years, which is what a lot of organizations do by default. So it's also always important to have a clear retention schedule and policy, which you can utilize to ensure that you're only keeping personal data that is necessary for your business purposes. Also, I'm pretty sure that Nigel didn't say that emails are not searched. Emails will be searched, and the general rule is that you should search every area of your organization's data storage where that person's personal data might be. And we're going to touch on this when we discuss what a proportionate and reasonable search is.
Yeah, let's come back to Brenda's point when we talk about proportionate searches. Right. Just to follow in on personal data. So as practitioners, colleagues on the call, the first thing you should always think about is when we come to subject access requests is one, are you the data controller? So that's the first thing. If you are the data controller, you have the responsibility for fulfilling the obligation under Article 15. So that's the starting point. The second point is you then ask yourself, is it personal data? So I call it the personal data issue. So let's establish if it's personal data they're requesting. If it's not personal data, then if you're a public authority, it could be FOI, it could be environmental information regulations. But if it's not personal data, it is not a subject access request. So that's the third thing. Now, look, the bottom line is Durrant case, which I talked to you about earlier, was really should be set aside. Another case, which is called EDAM versus the Information Commissioner and the Financial Service Authority. Cutting a very long story short, it was somebody who wanted the names of 3 junior officials who was investigating a complaint that EDAM had over Egg Bank, and they wanted the names of the 3 junior officials in the organisation. And the judge at the time in that case said clearly people's names off personal data. Absolutely clearly, you know, it was actually, funny enough, it was an FOI case rather than a data protection case, but clearly the names mentioned. However, because it was FOI, they weren't released because of the personal data exemption that exists within FOI. So when we consider personal data, we have to be quite sensitive about what is personal data. But the key thing about applying what personal data is, what has a relevance to the individual? Does it have substance about the individual? So the first test is one, is the information requesting, are you the controller? Two, is the information being requested personal data? If so, yes. Does it relate to them? If so, no. A good example was that one client I worked with, and it was offshore, so it wasn't a UK client, but a client I worked with offshore. It was a public authority based in a jurisdiction which had a data protection legislation very similar to the Data Protection Act, very similar to GDPR, had the right of access almost identical. And we had a trade union official. A trade union official wanted 17 years of their personal data when they attended discipline hearings or hearings when the organization was dealing with an employee. Now, I sat down with the at the time the jurisdiction solicitor, and we worked through that actually the data connected in those reports, in those minutes of those meetings, whilst that individual may have been there, they didn't have the right to those reports, because actually those reports were about a third party. They were about the person that they were representing. And we stuck to our guns on this. We said, no, you're not having that information, because we believe the information, the personal data contained in there doesn't relate to that. The fact that you were sat in the meeting and you were taking notes was absolutely superfluous to the fact is that the personal data contained within those minutes and those reports of those discipline hearings or those grievance hearings, for an example, only related to the other person that you were representing. So that was a good example that they couldn't use the subject access legislation that exists within that country because it wasn't about them. It didn't relate to them. It related to someone else. Now, Brenda, if, for example, an email says, actually, this is a performance-related issue about a member of staff, and that member of staff has then put that in to their personal file, then clearly that's in scope because you've named the individual and it relates to them because it's about personal performance. In scope, absolutely. But if, for example, that person is just merely mentioned in an email, for example, you're talking about the new policy related to staff cycle to work scheme, for example, and they merely are included in with it or CC'd within it, or they're expected to make a decision on the staff cycle to work, then that's not their personal data. That's about a staff cycle to work scheme. So you have to weigh up when you consider what personal data and what relates to it and what has a substance about them. You have to weigh up those exercises. Kunbi, sorry, I'm stealing your show.
No, thank you very much. I think that was a very brilliant explanation of it. And just to, in that particular context of the union, at best, what you would have to produce to provide to that person is maybe a list identifying which particular sittings or hearings they attended, because then that's your personal data because it relates to actions they've taken and that the organization has a record of. But yes, like Nigel said, absolutely in that kind of instance, you have no obligation to provide them with any complete documents that relate to the reports or investigations that were conducted directly in relation to another employee. So next slide, please.
Now, just before we go on that, and Adrian will come back to that point in a minute where we talk about searching. Just before we go, I've had circumstances in the last 5 years when let's face it, you get a subject access request majority of the time when someone is disgruntled about you or your organization. They want to do something with your organization, for example, looking at future legal action, or they might want to find out about information. They might go on a fishing expedition because they believe there is something going on in the organization, if they're employees, for example, or they've been dismissed, or there's a grievance. So people tend to, they're looking for recompense of some format. My experiences in this field that the vast majority of organizations face subject access requests when someone is disgruntled with an organization. Now, I've had a case whereby an investigation was taking place and a member of staff had been suspended. That member of staff had been suspended and was facing an investigation. The report that was taking place on that individual's competence was actually still being in draft form, but was likely to be published in final form, and the individual would see it in 6 weeks' time. The individual put in a subject access request requiring 21 years of their service. And when you went back to the individual and said, look, do you really want 21 years of your service? Or do you really only want to see the report? And the answer was actually, I only want to see the report. And a conversation then took place between the data controller and the data subject, who said, look, absolutely get the reason why. It's currently in draft format, but it will be done in 4 to 6 weeks. When it's done, I will make sure that you get a copy. Are you okay with that? And the answer was yes. So there are ways whereby, for example, that you can quite simply, by having an honest and open discussion with the data subject, establish the motives, and bear in mind that subject access requests are motive free. So therefore you are not to investigate the motive and not necessarily look at the reasons behind it when you initially consider it. But there is a dialogue to be had between you and the data subject. So don't get defensive. My advice to you is you can save yourself an awful lot of time if you chat to the data subject and say, what is it you really want? Kunbi, sorry.
Thank you very much, Nigel. The overview of the process that we take when we're addressing subject access requests and that we advise for clients as well, this is what we have on screen. So the first step is to validate, and Daniel, we're going to come to that question because it's quite a sensitive area in terms of how you can ask requesters to refine their requests. So they have no obligation to do that, and you really, there's a thin line there. We're going to come to that in a bit. So first is to validate the subject access request, and the second one is to log it, inform the relevant persons who are going to be responsible for 1, conducting the search, 2, collating information, and 3, replying and notifying the data subject about what decision has been made and providing the data to them. So 3 is to verify their identity if necessary, and 4 is to determine if you need more information. 5 is to search, find the data. 6 is to review and redact it. And last one is to reply, obviously. So Emma, could we have the next slide, please? So yes, we have this very nifty graphic showing you what the process is like for handling a data subject access request.
Kunbi and Emma, are people able to get a copy of these slides? Because this is very good. This is a really good process map, actually.
Yes, I believe so. I'm sure
yeah, cool.
We'll just confirm and
cool.
So.
Okay, thank you, Kunbi. Yeah.
Yeah, so with regard to the map, essentially, as you can see, it starts with receiving it, logging it, you then acknowledge the receipt. And this is important, as Adrian said in the chat earlier, and as Nigel said earlier, here's where you have a chance to begin to set a sort of good relationship in terms of being able to engage with the data subject and potentially get them to reduce the scale of their request if appropriate, as opposed to sometimes we've seen people take a combative approach, which is very unproductive, because ultimately, if you're processing someone's personal data, you have an obligation to provide them with that data if they request for it. That's the bottom line default position, because it's your decision as controller of the data to 1, collect the data, 2, process the data, and 3, keep that data. So if it's in your custody, they're fully entitled to request for that data, no matter how much of a hassle it's going to be to you. So here's where you have to begin as an organization to prioritize having a good relationship, even if it's a request that was born of some sort of acrimony originally. Anyway, the third step is to determine if you require further proof of identification. And
can I just,
yes.
Can I ask all those people on the call just for some thoughts? I'll give you an example that happened to me. So about 2019, we had a client, and the client member of staff had put in a grievance against the organization. So remember what I said earlier, that people get aggrieved, they put in grievances against the organization, but that client's member of staff had left. They then put in a subject access request. The subject access request, say, started on the 1st of October. About the 14th of October, a date was set for the grievance hearing, despite the fact that the individual had left, was set. And then the data subject came back and said, actually, let's pause the subject access request. But if I don't like the outcome of the grievance, I'm going to restart the subject access request. So for everyone on the call, what are your thoughts as practitioners? What are your thoughts, practitioners? What does the law tell us on that issue? What does the guidance tell us on the issue? That the data subject, 14 days after you have done an awful lot of exercise, you've done an awful lot of searching, you've looked at it, all of a sudden you say, hang on, let's wait for the grievance, that's taking place next week. And if I need any information, I'll come back and ask you to restart the clock, which is currently on 14 days. What are people's views on the call at the moment? I'm just intrigued on your views on the call on that one.
All right. So
hang on, Kunbi, just by all means type them into the box, and I'll give you my guidance I gave to the client from there. So just think about that. Can a data subject ask you to pause, and then if they don't like the outcome of an activity, then ask you to restart the clock, and you've only got 14 days left? That's the question. Kunbi, all yours.
All right. Thank you very much, Nigel. So yes, with regard to the process, you determine if you require further ID, and ultimately you request for that ID. At that point, the clock stops. And if they provide you with that ID, you move on to the next step. If they do not provide you with that ID, you notify the data subject that the subject access request is closed. Now, even though it says request proof of identification, bear in mind that this does not automatically indicate that you should request for an identification document, which is what many organizations default to. But that's problematic, because what it means is that you are taking on additional personal data that you would have to be responsible for, and that they could very potentially, put in another subject access request for down the line. So,
yeah, that could be, but yeah, I get that. But why does the legislation suggest that you need ID?
The entire point is that only an individual, subject to certain exceptions, is entitled to their own personal data. So you should provide that personal data only to the data subject whom you are sure is the person who's requesting for it. So the reason for saying that you might request for proof of identification is to be sure that the individual who is entitled to that data is the one who is making that request, and that you're not giving it to a third party. So in practice, what we recommend is for organizations to explore non-invasive measures, so to speak, in terms of, as opposed to, say, asking someone to provide you with their driver's license or national passport, you might explore another less intrusive method, because the ICO guidance says you should explore proportionate and reasonable measures to verify identity. So a simple one is, if you run a website, for instance, and an individual has supplied you with their contact information in the past, you might simply request that they, confirm that request through the email address or phone number that you already have on file, as opposed to
and could be, if it's an employee and they're emailing you off their work address, you're not going to ask them for their passport.
No.
You're not going to be asking for their driving license. You're not going to be asking for any of that any of that stuff.
Yeah, and also if they are emailing you from their phone, because obviously they can send a subject access request via their phone as well. The point of a subject access request is that it can be made in any means, through even orally, right? So as long as it's a method of communication that you already have on file, then it's absolutely legitimate to assume that that is the same individual who is contacting you. So the next step 4 is to decide whether you need further information to be able to respond to the subject access request. So this is where you go to ask for any sort of clarifications that you need, like the example that Nigel gave about the report. The 5th step is to collect the relevant information to conduct the search and extract the information. Then you assess whether any exemptions apply. So this is where you will evaluate the list of exemptions that we're going to come to in a bit, and then remove whatever information is covered by one or more of the exemptions.
Cool.
Yes.
Yeah, let's get into the detail. That would be great.
Yeah, we will. We will. We have an entire slide covering exemptions, so we'll get to that. But the next step is then to redact other data subjects' personal data, and then obviously respond, and then log the SAR. Now, if you see in the course, in the entire, almost everywhere in this chart, we've mentioned about logging the SAR. This is important because one of the principles in Article 5 of the GDPR, again, is accountability, and it's possibly, one of the most important, in the sense that if your organization has been reported to the ICO, or there's any other cause for investigation of your practices with regard to personal data, one of the most crucial determinant of whether you'll be penalized or not, or what kind of penalty you might get, is if you can show a clear audit trail that justifies your actions with regard to all the personal data you hold and with regard to specific requests, right? So because the ICO will be looking to see what your justification was for determining that you do not have enough information to verify the person's identity, for determining if you needed to apply for an extension of time, or for determining that you wanted to redact this information or that information. So it's extremely important to log and keep copious records of your treatment of any subject access request. And this is a very good approach we take, and we think from the beginning you should then begin to assign timelines to be sure that you are on track. The next slide, please.
No, there's a great discussion going on about my example, and I absolutely love it. So my view is fairly straightforward. What I always tell practitioners is say, what does the law say? What does the law say? So there's Article 15 and the subsequent recitals that sit next to it. What does the law say? If someone requests a subject access request, the law, when it was originally developed in 1984, 1998, and 2018, successive sponsoring ministers made statements in the House of Commons to say that the law is a balance between the data subject and the data controller, and it should not put undue burdens on the data controller. So with that in mind, we have to consider that if someone wishes to wait until the outcome of a grievance on a subject access request, is that a reasonable and proportionate activity for a data controller to have spent 14 days, spent money, and put resources into that activity? Because the individual might come back 2 weeks after the grievance and say, actually, I want something else. I want different pieces of personal data related to my grievance. I don't particularly like the outcome. You can't be held ransom by a data subject. We have to be reasonable proportionate here. It is not right for a data controller. The law is not the intent of the lawmakers to ensure that you have to dance the tune to every single data subject. So in this case, my advice to the lead counsel of the organization was, the law does not clearly deal with this. However, it is not reasonable proportionate to ask you to reconduct or restart, put on hold that data subject access request just because the individual doesn't like the outcome or might like the outcome of the grievance procedure. And someone earlier said about vexatious, and you could actually say that might be the case. However, my advice to you when you get those cases is just say, look, what's the reasonable portion for my organization? Is it reasonable portion that all of a sudden we're going to stop and start again? You might say, Nigel, it's no effort at all. Don't worry, we can put it on hold. We can start again. It's no drama whatsoever. So it's each case on its own individual merits. It's each case on its context. But remember that you are not required to go beyond what is reasonable and proportionate. And also, you're not required to do things which are burdensome, which was not in the intention of the law when it was made. Kunbi.
Thank you very much, Nigel. So I'm going to put a link in the chat that refers to, because I think Nigel has raised a very crucial point with regard to what might be considered to be a vexatious or manifestly excessive request. And the factors that the ICO has put out there are 4 of them. The first is one, that the individual has explicitly stated that their request is intended to cause disruption. The second one is that they are making up substantiated accusations against your specific employees. The third one is that they are targeting a particular employee. And the fourth one is that they are sending systematic and frequent requests that are intended to cause disruption. So, I mean, it would depend on the specifics of that example, like Nigel has said, but there's an argument to be made for the fact that the person is deliberately trying to use that request as a wedge, as some sort of, something to just beat over the organization's head in order to get their way. So ultimately, it have to be based on the specifics again, but it's one context that you should bear in mind, that the law requires you to take a proportionate and reasonable effort to provide the data that's been requested. It does not require you to suspend all activities of the organization in order to comply.
Absolutely. And Kunbi, one that I've seen and dealt with is quite interesting, is an organization which was targeted by 4,000 residents all at the same time using the same subject access request. And that was clearly vexatious because it was clearly an organised campaign, and therefore it was not reasonably proportionate, overburdensome, and the organisation couldn't do that. And couldn't do that. The only reason that was done was to frustrate the organisation from carrying on its day-to-day business. And that's not the intention of lawmakers. That's not reasonably proportionate. And the ICO agreed with the organisation to say, yeah, it's on a vexatious basis. Anyway, we need to crack on. What about validation of a subject?
Yeah, so on validation, we've touched on this, but the key point is to recognize that a subject access request can be made to any staff of the organization through any means, right? So this may be orally, in writing, via social media, via Twitter, via Facebook. If your organization has a presence there, and a person has been contacted in their official capacity as requesting for their personal data, then yes, that's a subject access request. Also bear in mind that of recent, there has been an increase in the number of online services, portals that offer to, push subject access requests to organizations. Again, you have to respond to them. All you have to do at this point is to validate that the data subject in question has made that request, that just to be sure that the request is a legitimate one coming from the only source which you would have an obligation to respond to, which is the data subject. Now, the ICO has provided guidance with regard to this, which is that one, you do not have an obligation to treat that data subject access request if the portal requires you to take any active steps in order to verify the identity of the data subject. So if you're required to sign up to that portal, then that's not a valid request. If you're required to provide any sort of information on your own part, then that's not a valid subject access request. So it's an entirely passive procedure in terms of you receiving the request. Where it becomes active is in ensuring that your staff are trained to recognize what a subject access request is, and letting them know that the subject access request might not state that it is a subject access request, might not cite the GDPR or the Data Protection Act. It might even, and we've seen this in many instances, cite the wrong law. So a person might request for their personal data and cite the Freedom of Information Act or the Environmental Information Regulations. It's irrelevant. The law requires you to treat the request under the appropriate regulation, which in this case is going to be the GDPR and the Data Protection Act. And this is where, again, having a clear procedure is crucial, like what Nigel said at the very beginning of this session. It helps to align the entire organization, make clear what the processes are for searching, finding, redacting, reviewing, and replying, and makes it a much more streamlined and efficient procedure. So absolutely, if there's any organization that has been receiving SARs and it does not have a policy, that's a big problem. It's going to mean that you're going to be spending a lot more time and effort trying to resolve each process on an individual basis, as opposed to having clear and defined procedures that staff can follow on a regular basis. Can we have the next
now,
slide?
now, Kunbi, one question that Adrian asked earlier, I think it was Adrian, wasn't it? Asked earlier about processes. So where you have a processor processing personal data on your behalf, and so you might have an environment, and I've worked in this environment whereby a organization is a processor on behalf of a number of utility retailers. The controller in the organization is the utility retailer, but the processor processes a lot of personal data on the individuals because they're the processor. And we've had members of the public go straight to the processor. In that case, it's quite straightforward. And I've shown you Article 28 there, that you need a clear gateway. You need a clear gateway and pathway that, one, returns that data subject back to the data controller. Because if we remember in Article 15, the first statement, what does the law say? The law says the data controller will be responsible for fulfilling the obligations of the subject access request. So therefore, you need to get the processor to have a loop back into you to ensure that you can process that personal subject access request. And then secondly, in your contracts that you have between you and the processor, you need to make it clear. You need to make it clear that in your contract you have and your working arrangements that you have that they have an obligation to, for example, search their databases or provide you with any information that they need to provide you with reference to the personal data that might be on that individual. So just remember that it's not just the controller involved in this party. If there are two people in the marriage, i.e. the controller and the processor needs to be brought into your controller's policies and procedures to ensure that the data subject can get the access to the information from the controller.
Thank you, Nigel. So that answers the question of if a request is placed to a processor as opposed to a controller. But if Adrian, within the context of if a request is made to a controller, does that controller have an obligation to search or ask their processors to search? The answer to that is yes. A subject access request entitles the data subject to any information that is their personal data, as we've explained before, that the organization is the controller of. So if you're the controller for that data, it doesn't matter whether it's in your direct custody or if it's held on your behalf by another organization, you have an obligation to search and provide it, subject to the principle that the search must be a reasonable and proportionate search. And we're going to touch on that very shortly. Now, a SAR log is what we explained before, how it's important to keep a clear, definite record of every subject access request that you get, and also track its process through your policies that you ideally have to ensure that everything is on time and that you can respond to this request within the compliance time period. If you recall the slide we had about the enforcement action by the ICO, a lot of the complaints were about delays in responding. So one of the examples that the ICO specifically highlighted in their website was somebody who had made a request in January and was getting their first response, I believe, was in March, right? Which is, 3 months, depending on when the specific dates within those months were. Ultimately, what that means is that the ICO frowns at, delaying requests. And this is especially important for public organizations where the information being requested might be ones that have a direct impact on the people's lives. For instance, if it's medical records, care records, and things like that. So the second one is to schedule reminders. Now, you can do this in a variety of ways. You can use emails. You can, pre-schedule emails. You can set reminders in the organization's calendar. But the key thing is to keep everyone on track. The third one is to show you're working. And this is, again, the accountability principle. It's the only way you're going to get out of being slapped with a fine or something if there has been an issue with the SAR and someone has made a report to the ICO. You would have an obligation to show that you went through a logical, legally justifiable process to determine that you did not have to respond to the SAR, or that if you did, that you were entitled to remove this or that information. Now, how you can do this entire process is up to the organization. You can use a spreadsheet, you can use any other sort of record. But can we have the next slide? One thing that we found to be useful is, can we have the next slide, please? One thing that we found to be useful is using software. And at DPAS, we have Responsum as partners. This is just notifying you about the fact that you can use software. There's a variety of providers, but we use Responsum and we've worked with them and we've seen, it's quite effective in enabling organizations to keep, records of subject access requests, enter the justification, give permissions to all the officials involved to edit and identify exactly what is happening with the request, such that it's easy to export. Can we have the next slide, please? Such that it's easy to export and notify the ICO of the entire timeline, processes, justification, assessments that were conducted in the course of responding to that request. So you can find a variety of software available. We recommend Responsum, and if you're interested in that, please feel free to reach out to DPAS. Can we have the next slide, please? Now, acknowledging the request. And this is where you have to start building that very good relationship that we spoke about. And you need to do this by first letting them know that you have received the request and you're going to be treating it under X law, which in this case is going to be the GDPR or Data Protection Act. And this is because, as we said earlier, sometimes data subjects might make that request based on the wrong piece of legislation, right? So the next thing is going to be to notify them of your expected timeline and, where applicable, verify the requester's identity. We're going to touch on this now. But with regard to timeline, we're all aware that the timeline is 30 days, although there are certain circumstances in which that can be extended. But the default is to release that information, and I'm quoting directly now, without undue delay, but at worst within 30 days. So
now, Kunbi, one bit of advice for everyone. One bit of advice from my own personal experience is that it's always good at this point to say we intend to, subject to review after a reasonable proportionate search, to fulfill your obligation under 30 days. If it is likely to be more than this, following our search for personal data, we will get back to you within 7 to 10 days. It's really important to set expectations at the starting point with the data subject about the likelihood. And I just saw in the chat box earlier about complex SARs. I'm advising on a DPO issue to a client at the moment, and it goes back 3-4 years, and there are a considerable amount of bits of personal data. We haven't even started thinking about redaction yet, and I'll tell you how we dealt with that a bit later. But it's reasonably sensible to have a setting of expectations at that point that you will get back to them if you believe that you need to extend this further.
Yeah, that's entirely true. Ultimately, the goal.
Yeah, and let me just pick one thing up, and it's, you have to be really, really careful. Whilst you say, oh, we might work in health, we work in an environment where there's lots of records, etc. If you are setting a default position whereby it'll be 3 months, it'll be 3 months, it'll be 3 months, you're taking away individuals' rights in the end, and you're at risk of setting and breaking the law, because the law is quite simple, that it's 30 days unless there are exceptions. So only with an exception should you extend it to 3 months. The law says 30 days. That's what the law says. You can extend it under exception. If that becomes the norm, then I believe on a personal level that you're stretching the intention of the law and you're on risky ground. So just be careful saying medical records, 3 months. No, just say we expect to deliver it in 30 days. However, there may be a requirement for us to extend that once we've done our reasonable proportionate search. So just be careful. Just be careful about actually defaulting to a position which is not defined in law. Cool. Sorry, Kunbi. Yeah.
Thank you. Like Nigel said, yes, it's not something to default to. It's something that you have, again, and this goes back to the principle of accountability. It's something that you have to be able to show, if necessary, that you had a reasonable justification for doing. So on one hand, it's good to want to give, you know, the data subject as much upfront notice in terms of timelines as possible. On the other hand, you must recognize, and this goes into the question that Adrian asked about how complex isn't simply a matter of size. No, it isn't simply a matter of size. There are a variety of factors that need to be taken into consideration, including, you know, the size of the organization, you know, the kinds of resources available. But you must bear in mind that the obligation is on your organization to provide that data within the law's set time periods, right? And ultimately, you would have to be able to justify why you aren't, you know, doing it. For instance, if your organization, other organizations are able to deliver these same sorts of requests within the 30-day period, it would not be an acceptable defense to the ICO to just say, well, it was going to take us longer, because it's your obligation to facilitate access by data subjects to their personal data as quickly as possible and within the timeline. So on one hand, yes, be upfront and, you know, be as provide as much information and context as possible. On the other hand, recognize that you cannot default to extending the timeline automatically, and that you have to make sure on a case-by-case basis, it's reasonable to make, you know, any sort of extensions that are necessary. If you have to get more staff to outsource it, it's your responsibility to facilitate access to the data as quickly as possible, not the data subjects to be accommodating. So it's only in cases where you can justify that you should be letting them know that it might take longer than that. So yes.
Oh, next slide. Let's go next slide then. Yeah.
Yeah, next slide, please, Emma. So this is where we are going to verify the person's identity, and we've touched on this already, so I'm not going to spend too much time on it. You need to be able to do this in a way that's reasonable and proportionate. That is exactly what the ICO says. So again, avoid collecting additional information, especially sensitive personal data or special category personal data, because then you might be putting yourself in a position whereby you have more data that you are now responsible for. So if you
however, Kunbi, I disagree with the ICO on this one. That the ICO says, oh, well, you shouldn't really actually ask for all this information, that's the thing. If you have any doubt, ask for the information, because you do not want a data breach of someone's medical records. You do not want any of that nonsense going on, because all, you know, there are actors out there at the moment trying to steal information. They are currently, you may have seen that the 7 or 8 celebrities are taking a national newspaper to the courts on the basis of theft of personal data through actors trying to access information through subject access requests. So look, I would absolutely advise you to, but clearly if it's a member of staff, you know them, it's come through a staff email, that's different. If it's an individual, they've come through a Hotmail, they've come through a Gmail, you're uncertain, say, prove who you are, and then we'll provide the information, because the last thing you want to do is expose sensitive, special characteristic data to an actor who is most probably has ulterior motives for that. The vast majority of subject access requests are genuine, but there will be actors out there trying to nick vital, sensitive, personal information on an individual. So this is really important.
Thank you, Nigel. I think that's completely correct. Again, it boils down to the organization's discretion in terms of what the risk inherent in that data is, and how much verification they think is necessary to be sure that they are preventing a data breach. So a couple of people have asked questions about specific types of identity documents, so expired passports, torn birth certificates. Again, it depends on how important how sensitive the data that you hold is, and how risky you think it might be to provide it on the basis of those documents. Again, it's going to be up to the organization to determine that, and it's going to be up to them to be able to show the ICO that this was a reasonable determination to make in that particular instance. So, and I see someone has mentioned about people using stolen identity cards and signature that has been forged and so on and so forth. what is ultimately what I would say now, away strictly from the data protection field, but from a legal standpoint, is that organizations and people have an obligation to act within the context of what is reasonably expected of them. So organizations cannot be expected to take on the burden of becoming law enforcement agencies in order to identify, the most extreme cases of any sort of, personal identity theft. But you have an obligation to set a high standard to be sure that you can show that you acted reasonably to prevent any sort of breach. And I would say, like Nigel did, that ultimately, if you're looking for a baseline to work with, I would say that as a baseline, it's reasonable to set a higher standard in order to prevent data breaches, than to set a lower standard to make it easy and then have a risk of data breaches. So, I mean, yes, it boils down to each case, but overcompensate rather than undercompensate, as it were. If Nigel doesn't have anything to add, can we have the next slide, please? So here's where you begin to clarify the request. And we've had a question about this where someone asked if you can ask them to narrow the request. So no, you can't ask them to narrow the request. And this is sort of, like I said, it's a dicey area. You can't ask them to narrow the request. Yes, Adrian, it certainly is a fine line. So it's going to be determinant on the specifics of each case. Yes, so clarifying the request, you can't ask them to narrow the request, but what you can do is to seek for clarity. And in the course of seeking that clarity, by trying to assist them, you can, possibly get a sense of what specifics they want. And the ICO does not forbid having a discussion with a data subject as to what exactly they're trying to accomplish, because the goal of the subject access right in Article 15, it doesn't state that, a person, must, and every single time they ask for their data, be given the entirety of their data, because it recognizes that a person might want a specific component of their data. So you are actually assisting them, if it applies in that case, to get the information that they want. So this is where it boils down to, getting a good sort of rapport going on, engaging with them and saying, also, can we clarify what exactly you want and things like that. But you shouldn't ask them to narrow the request. They have no obligation to do that. Bear in mind that even if you are being as nice as possible, they have no obligation to do that. They have a right to request for all their data. As I mentioned earlier, it was your organization's decision to collect, process, and keep that personal data. So you have an obligation to provide it, again, subject to the undertaking of a reasonable and proportionate search to provide that information. So again, these are the factors where you genuinely believe that you require further information to process the request. And two, you process a huge amount of data whereby it might then pose a conflict between responding in appropriate compliant time and being able to provide them all the data. So again, just make sure you're taking decisions that you can justify to say it was reasonable for us to seek this clarification. Can we have the next slide, please? So the next slide is what the search requirements are. Now, the factors you need to consider when undertaking this search, and this is where we're discussing the proportionate and reasonable search, what exactly it entails. So the first thing is to understand that you have personal data that is in scope, whether it's electronically stored, such as in emails or other communication channels, or personal data that is stored in manual filing systems. Now, the determination here is that that manual filing system must be one that uses a structured approach to filing of the data. So it shouldn't be that you're going through, random notes that have been made on crumpled pieces of paper around the office. It should be information that has been created and entered into structured filing systems that the organization uses to store personal data, generally speaking, in the course of its operations. Now,
Kunbi, manual filing systems is one of my favorite subjects. Yes, I know I'm dull, I know I'm boring, but when we went back to that seminal case, Durant, the legislation, when it was enacted in 84, 98, 2018, every single minister before, Leon Britton in 84, the sponsoring minister, Waddington in 98, and Matt Hancock, who was the sponsoring minister in 2017 for the Act, didn't want to place an undue burden on the data controllers. And in essence, the law has developed under manual filing system from Durham on the basis of a manual filing system should have the ease of search that electronic data system has. So if we now all go into our inboxes, we can find, for example, I'm going away on holiday and the end of next week. I was looking for a flight. I can go into my inbox. I can search for the flight company, and all the emails pop up. Simple as that. And the whole idea about manual filing systems is really that the first seminal case, Durrant, and there was then a case in two cases, Alida and Dawson Damer, really actually got us to the stage whereby that when we're thinking about manual filing systems, they should have the ease to be able to search for personal data that a computer filing system has. And those two later cases, Alida and also Dawson Damer, really was the ICO changed its guidance in code and practice to say that when undertaking activity, when responding to requests for personal data that resides in a manual filing system, that it must be not unreasonable, disproportionate, and search must be somewhat reasonable. And one of the interesting things that came out of the last one, the Dawson Damer case, was that actually the temp test arrived, that the ability to search a manual filing system for personal data should be undertaken by someone who has been employed for a day and not a trained lawyer to be able to search that information. So manual filing systems have to be, as quite rightly says, Kunbi said, in a structured way of which you can search easily, and you can also get temp in during the day to actually look for that information and search. That would be deemed reasonable, and that actually sits in the ICO guidance as well because of those two cases.
Perfect. Maybe Nigel is going to put that case in the chat. Ruth, thank you very much, Nigel. Can we have the next slide, please, so that we can discuss, what a reasonable and proportionate search is when you're collating the information. Now, when you're collating the information, there are a number of pointers that you must bear in mind. The first one is that, generally speaking, again, we keep repeating this, but that's because it's extremely crucial. It's best to have clear procedures and policies that you just haven't, drafted and put in the personal computer of the data protection officer, but that you have actually trained and sensitized your staff on about how to conduct a search in response to a subject access request, such that there's a clear, repeatable process for getting data subjects access to their requests, to their personal data within, the compliance time period, and to avoid, going back to, yes, that is temp test essentially, to going back to the ICO and having to clarify and undertaking it again. So if you do not have a policy, it's important to put that in place and to train staff for the entire end-to-end process, from identifying a request to undertaking the search and collating the information. So the second point is that where there have been multiple requests for data, and this might go into, I think, like someone asked earlier about certain organizations that have a deluge of requests, so to speak, such that it has become consistently difficult to deliver them within the compliance timeline, then it is your responsibility again to implement software procedures, staffing changes, operational changes that would be necessary to make sure that you are able to provide the data within the compliance timeline. Again, it's not the responsibility of the data subjects to wait. It's your responsibility to provide it within the timeline, unless an exception applies, as Nigel helpfully clarified earlier. Ultimately, the goal is to ensure that you are constantly evaluating your procedures and taking whatever steps need to be taken. So if you're a professional here, for instance, it might be the right time to show the superiors at the next budget meeting about how the ICO has been responding to delays in subject access request responses, and using that to ensure that they are aware that by not providing you with the appropriate resources, they're putting the organization at risk. Ultimately, again, it boils down to the fact that you have an obligation to provide the data, and you must do your best to get it there as quickly as possible. So if that involves getting software, or doing other changes, you have that obligation. The third
one thing I've seen a client do when I acting in my DPO capacity is that they had someone who was asking for about 3-4 years information, and what they did was they produced a framework. So they produced a Excel spreadsheet with the framework. It was the after they'd done their reasonable proportionate search, it was a fairly easy search because it's all computer records, so fairly easy to search. They then got someone then to list the 30 documents of which they turned up in emails, documents, records, list them. They then actually went through each of the 300 documents, and on the next column actually identified whether their personal data, whether they thought that was in scope. And they then put on the right-hand side, so the next column said the ease of access and the ease of which they could forward to the individual. So therefore, would it be burdensome? Would it be reasonably proportionate to give this information? And a lot of them were actually on the low effort side. So actually they were able to actually justify that how long it would take them, how many people hours that they would need to be able to fulfill the obligation. And it was a really good discussion with the individual, because they sent the spreadsheet to the individual. And the individual then went back through the spreadsheet and said, I don't need that, I don't need that, I need this, I need that. And it was a really great tool to use. So don't be scared to use that tool. List the documents of which that you've got personal data contained in, rank them in terms of ease of being able to get out, and then say to the data subject, which ones of these do you want? Because it's going to take us a lot of time. And actually, if you really want to achieve what you want to achieve for the subject access request, we would suggest that you go to these documents. And actually, that was a really good two-way conversation with the individual. Of course, the other thing, Kunbi, as well, is that if you then say, actually, it's burdensome and it is actually not reasonably proportionate for us to provide this personal data, you then got a template to show if that individual complains, if they don't agree with some of the things that you're not prepared to go and search for or do the work on because you think it's burdensome.
I agree. Ultimately, it boils down to being able to show, to any person who will be reviewing that action that, you made the correct decision, the justifiable decision at that point in time. The last point on the collation of information is that you must not take a blanket approach to rejecting any request on the basis that is unreasonable or disproportionate. It has to be taken on the basis of, if the person has requested for different pieces of information, they have to be addressed on their individual merits and on their individual difficulty respectively to access, which is exactly what Nigel has said. And it's also important to bear in mind the scope here. We have touched on this, but I'm actually kind of surprised that we hadn't gotten a question about whether or not you have WhatsApp or Slack or other sorts of social media applications in scope. And the answer simply is yes, if those software are being used for business purposes under the authorization of the organization, then in such instances, the data contained there is data that the organization is the controller for and is therefore responsible to search for and provide relevant personal data from when a data subject access request has been made. So again,
no, Kunbi, I'm going to ask you a question then. I'm going to ask you a question. What about bring your own device, personal phones, laptops? What if, for example, I'm corresponding with an HR manager about an individual and I send to their Gmail account? Are those in scope?
Yes. The key thing is this, and this is based on guidance from the ICO, as well as it hasn't been tested in court yet, so there's still some ambiguity, but ultimately, again, it's one of those things where you don't want to be organization who is used for that test case and then, found to be, lacking in how you've approached it. It is the obligation of the organization. And at DPAS, when we're undertaking an audit and we're doing remediation work for organizations, we always, recommend that, you have a clear policy in place for bring your own device. You have a clear policy in place for remote working, identifying exactly in what circumstances staff are able and entitled to keep and process personal data in their personal devices or off-site. In such instances, it is your responsibility to make sure that you are not allowing staff to keep personal data on their devices or off-site. But if you are, and it's not necessarily a bad thing because it might be necessary simply for business efficiency, if you are, you must bear in mind that you are responsible for that data. So if you have a WhatsApp group that is used for discussing things with regard to work, that WhatsApp group is in scope for the personal data of any person who is contained in it. So if Nigel were to send me the list of all the attendees here, via WhatsApp message, that it would be in scope because it's a business purpose. But he won't do that because, at DPAS we have very high standards of data protection.
And I don't know how to use the email system.
So ultimately, it will be in scope, and that is why you have to have clear policies in place to be sure that you are minimizing your exposure for any sort of actions. So
yeah, yes. and Kunbi, what I've done is just put in the chat box, by the way, some advice from the ICO on guidance on FOI. So to be quite frank, if it's in scope for FOI, then you can see the ICO are considering it to be in scope for subject access requests. Isn't that right? Yeah.
Totally. And
yes, and there's a couple of ideas for if anyone uses email search tools, put them in the chat box. Sophia has answered to Julie's question. So by all means, if anyone using any software, the whole idea is about this learning must add value to you. And if you can add value by some other systems, then by all means, put them in the software. Sorry, the chat box. Yeah. Sorry,
yeah, thank you very much. I was just going to say that people should check that, but I see our CEO Mel has provided quite a lot of information in that respect as well. Anyway, can we have the next slide, please? So redaction guidance, and again,
but Kunbi, why do we need to redact?
So you need to redact any information that falls under an applicable exemption, right? One of the most prominent of which is going to be that the personal data or the information contains the personal data of other persons. So this is going to be the primary reason why you are having to redact certain information, but there might be other reasons why. For instance, if that information falls under an exemption, such as the crime and law enforcement ongoing investigation exemptions, in such instances, you would have an obligation to redact such data as well from the information that you are providing to the data subject in response to their request. So in terms of tips that we think will be very helpful here, because I think everyone has a an overview understanding of this. We have a SAR course, so I mean, if anyone wants to delve much more deeply into the approach we take and recommend, we have a subject access request course that we have found to be very useful and that clients have found to be very useful. But in terms of tips, just to optimize that process, the first thing is to ensure that you have the original copy separate from the copy that is being reviewed, redacted, because what you would not want to do is to redact information in permanent form such that you then not have access to that information for business purposes, or in fact for if it's necessary to, maybe as Nigel has said, the subject access request was in response to a grievance that the person is intending to sue your organization, for instance, but now you've gone and redacted the original and now you do not have that original with which to defend yourself. So make sure that you have a process, again, instructing staff on how to begin to treat the documents that have been collated for the purpose of responding to a subject access request. So
now, Kunbi, some good practice I've seen in this area it's some good practice I've seen in this area in the past. We had a health and social care client who asked us to assist them with some redactions. And one of the challenges he had is that the participants in the subject access request, it was a young adult in care who now was 20. So therefore they were an adult in their own right. They weren't a minor under law. They were living out with local authority care, had requested documents about that child's upbringing. So the whole raison d'etre for the individual's request was they wanted to know about their life journey from when they were 3, taken into care, and for when they were and for their current time, and they wanted to know their journey, and so it's their life journey. And one of the challenges you had is that all the individuals that were involved in the process, i.e., parents, partners of parents, or partners of other people involved in the process were all still alive. So, and that might sound crazy, because if they're dead, as we know, if an individual is dead, then therefore that individual is not being in scope for GDPR because they're not a medical person. So that makes life a little bit different. However, all the participants were alive. And one of the challenges you've got in redaction is trying to establish whether it is right and proper to release information relative to that individual. Now, the example I'm going to give you now is a real life example that the individual was 3 or 4 health visitor goes around the house, couldn't gain access to the house, looked at the letterbox, parent of and guardian and carer of the child was in the afternoon was clearly inebriated, lying on the sofa, screaming and shouting at the child. Health visitor gets access to the rear door, and cutting a very long story short, conversation takes place between health visitor and child, mother, of which then mother says, if you don't take that second child away, then cutting a long story short, I will kill myself and that child. Now, for me, I have to make then a judgment. I then have to make a judgment that I'm doing the redacting of this. I get my hands dirty sometimes. I was doing the redacting on this. I have to make a judgment. The purpose of the child subject access request was understanding whether it was to understand how that individual got into care that night, and then that journey took place. I had to balance up 2 things. One of which, could I get consent of the mother who was still alive? 2, is there a law or regulation that allows me to expose the data of the third party? Or 3, is there substantial public interest based upon the reason for the subject access request that I could release that data? And I tell you what, I went back to that data controller 4 or 5 times. I sat with our staff here and mulled over whether I thought it was reasonable for that child, now adult, to understand how they got into the care system because of that event. And in my view, I felt that there was substantial public interest, which is one of the tests, 3 tests, one of which the third party gives you consent. 2, there is a law or regulation that says you have to name the individual. Or 3, there's substantial public interest. And I took it on the chin. I thought, right, I'm going to take this on the chin. I justified why I think the substantial public interest, and I did it on 3 grounds. One of which, the SAR was based upon an individual working out why he spent his life in care. 2, that the individual wanted to understand how he got here in the adult system. And 3, why did the relationship with parent break down? That was the raison d'etre. And so we released the individual's third name. However, whatever we redacted, the child, i.e. the young adult, would have known anyway because of the circumstances they would have found it. But if I'd have redacted out that whole incident, it had no value whatsoever in terms of the raison d'etre and the reason for doing it. So I think it's really important when we think about redaction is that you can release the names of the third parties, but it has to be based on that specific legal test. 1, consent of the individual. 2, law or regulation, or 3, substantial public interest.
Perfect. That's ideal. I think that's a very comprehensive explanation coupled with an example that brings it home. And ultimately, it just highlights how it's important to take a reasoned approach to any action that you're going to be taking in response to a SAR to be sure that you can make that explanation and justify it if necessary. The second step is with regard to making sure that the data is in an easily accessible format. Typically this is PDF, and I'm glad to see that's the consensus among practitioners based on the chat that almost everyone that has spoken uses PDF and uses one PDF editor or the other to be able to apply reductions and extract the information, compile it so that you can give it to the person who requested it in a format that is easily accessible. The third one is to use software. Again, we've touched on that, avoid a black marker pen and avoid digital black marker pens as well. Also, because there's been some news, there was a very prominent one, unfortunately I can't remember the instance, but an organization, a public organization, provided information. This was an FOI in which they had used a particular software to redact it, but they didn't use a redaction function. What they did was just put in a black mark over black blob, so to speak, or highlight over the text. Unfortunately for them, it turned out that when printed, it was possible to read what was beneath those, exactly, Adrian, it was possible to read what was beneath those texts, right? So clearly use software that has the function to redact completely to be sure you're not inadvertently releasing information you should not be releasing. Now, we also say sanitize your documents to remove hidden text and metadata. This is also something that will be highly dependent on what software you use and the functions it allows, but it's important to remove any hidden text that might be in the documents and also to remove metadata, because a lot of information can be discovered from the metadata of documents. You might be able to discover what has, who created the document in the first place, when it was created, what location it was created at. That's a costly mistake to make in certain instances. So make sure you apply those best practices. Again, it boils down to having clear procedures in place that guide organizations. So at DPAS, or by ourselves, and also on behalf of any organization, no matter how small or large the job is, the first step is to create a custom guidance for that particular redaction job, so to speak, and then have highlights as to what exactly needs to be done based on the kinds of data we expect to be provided with and how to approach each one of them, just to be sure that we have a consistent approach for that client. And that's also something for your organization. So you don't want to have one member of staff redact something, another member of staff leaves it in, because then it becomes difficult to justify why that decision was made if it becomes necessary. Can we have the next slide, please? Still on redaction guidance. Ultimately, the key considerations you need to consider are first, third-party data. Again, this is going to be the primary reason for which you would redact personal data. It's the most common exemption you are likely to have to apply. And bear in mind that it's not automatic. There are exceptions in which you might be able to leave personal data in. That is, if the other party has consented, or if it is reasonable to comply with the request without the third party's consent. Now, you must bear in mind that there is also a duty of confidentiality that might apply depending on the circumstances. And ultimately, decisions you would have to make are going to be based on the specifics of that request and the data in question. So you're going to have to consider if the relationship of that third party is one that would lead to a reasonable expectation that their personal data and their opinions, in fact, are redacted, such as if it's a legal relationship, for instance, and then legal professional privilege applies. Or, and this is from the ICO directly, the ICO gave an example of where the personal data of someone might be left in. And this is where they are acting in their professional capacity, such as in the case of a carer. So like the health visitor or someone who's acting in similar capacity. According to the ICO, in such instances, it would be reasonable for that person as a professional providing a service on behalf of the state to expect that their personal data is disclosed as the officer who made a recommendation or some other sort of determination, right? So again, it boils down to the specifics of the instance or specifics of each instance, and making sure that you're reaching the best decision that can be reached in each specific circumstances. The duty of confidentiality applies. Again, even if the person is dead, you still have some degree of the duty of confidentiality that you would have to weigh up against the desire of the person who is requesting information to have access to their personal data. And lastly, you're going to have to determine if any exemptions apply. Can we have the next slide, please?
And just before going to exemptions, it's a really good points that are being made, and thank you very much. Really interactive session. Thank you. Adrian, spot on. Context of the request and its motivation. So that's a really great point. And Kunbi just mentioned it. Every single issue is actually different. So you can't put one size fits all to the redactions and some of the issues and the context. If you redact the backside out of something which has then no meaning whatsoever to that individual, I could have redacted, for example, on that example I gave you, that the health visitor turned up and child was taken into care, and then the circumstances around that would have no meaning, no relativity to that individual who was requesting that. So I could have done that. I didn't. And some other good questions as well. I think Catherine raised a very good point, and you all did, by the way. So forgive me if I've not mentioned you about the fact that I already knew that the data subject knew that the individual's mother had a adverse relationship with drinking drugs. So I already knew that. So that was nothing new. So I was telling the individual, the data subject, nothing new about the circumstances of the taking into care. So I think it was. It was really important to find out the context. What did the individual know? What sort of relationship do you have now? And the other thing is that I think it was the other thing that I think was questioned was, let me just check who put it into. Sorry, excuse me, apologising there. Don't question we're acting in the best interest. Yeah. So Helen, good point about best interest. Look, ultimately, Article 15 says you work for the data controller. So you are working for the data controller. But ethically, the right thing to do is to provide information with their fundamental right to access and understand what information is being processed. Now, that doesn't mean, and there was a recent not judgment, but an opinion by the chief judge in the European Court of Justice, and though we're not duty bound by the Court of European Justice, it becomes persuasive recently that actually, whilst an individual has the right to understand what information, personal data, is processed about them, they don't necessarily have the right to dictate what you as data controllers do with it. That is your raison d'etre for being in business, because you process personal data to provide care, sell products, sell hotels, flights, that sort of thing. So there's a quite clear balance really between you, Helen, as a data controller, and also fulfilling the right. Most public authorities have an ethical stance towards it, and that's lovely, that's great. And I really appreciate that that's the right thing to do in those circumstances. But it's as Adrian quite rightly says, the context is absolutely complete. And there was one question I got asked about if you knew that one of the two individuals are at risk, i.e. the data subject was likely, once he found out about the incident, would go around and punch his mother when she opened the door, then clearly if I felt that either of those two individuals were both at harm, then I would use one of the exemptions that Kunbi's listed above. And Kunbi, back to you. That was a nice lead-in, wasn't it?
Yeah, thank you. So I just answered the question by Sylvia, and the point is, I'm just going to say what I was going to type additionally, is that HR should have, or whatever organization the SAR is most directly related to, should have an input in the compilation of any data you're proposing to release to the requester. But you must be cautious of the fact that you do not necessarily want to then make it a free for all, so to speak, where, you know, HR gets access to data that they would not have had access to, merely because, you know, their HR, for instance, if there was all that sensitive information that had to do, that was in a legal department, for instance, you don't want to make it available to everyone in HR, because data breaches can and have happened within organizations. So it doesn't necessarily have to be external. So you don't want to create a data breach inadvertently. So I would say that a better approach to it is to first recognize that the ultimate obligation rests with the information governance team and the data protection officer specifically. But if there's a need for additional third-party input, that's where you have third-party consultants or the solicitors, because they then have an established duty of confidentiality. So legal privilege covers them and ensures that you can say, well, we felt safe disclosing this to the solicitors because they have a duty of confidentiality that would have bound them anyway. So as opposed to making it available to any person who is in the HR department, that's quite dangerous. Now, the exemptions listed here are breached anyway, and you can find a longer list of them on the ICO website, along with some explanations and exemptions.
I'll just put them in the chat box, actually. So
exactly. Oh, thank you very much. Perfect. And ultimately, the thing is, it's impossible to cover all of them now. So again, we have a SAR course. I think we have a slide on that at the end of this. But what you have to bear in mind is that each one has to be taken on the basis of its applicability to the SAR in question. And ultimately, it boils down to experience in most instances, and by instinct, you then are able to determine this and write down the justification, because again, the justification is equally as important as giving the response. Can we have the next slide, please?
Can I just say one thing about exemptions? And look, if you are going to use an exemption, colleagues on the call, you're taking away someone's fundamental right. If you look through legislation, if you look at Schedule 2, for example, if you look at the things from GDPR you can exempt, the privacy notice, you don't have to tell people, for example, when you're sharing information with third parties because you're using an exemption, for example, or you're taking away their right to access personal data and their own personal data. You're taking a fundamental right. So you use exemptions sparingly, and you use them with great thought, and you use them within the systems and processes in your organization. So my view is that if you are thinking of using an exemption, you must think about, if I release this personal information, will this, for an example, have a detrimental effect, the reason why I'm passing that information on? And that could be, for example, you're passing on information to the local authority safeguarding board about concerns you have about a child in your school who's attended your doctor's surgery or attended A&E, for an example. And if clearly you then told the parents, then that would put the child at greater risk. So that's the reason why the exemptions are there, that you want to have an element of confidentiality to enable and keep everyone somewhat safe with that. So if you do use an exemption, please have in your compliance documents a clear justification that you're keeping on record why you're doing it. Kunbi, back to you.
Thank you very much, Nigel. So ultimately, I think Nigel has coined a very important phrase there. Use exceptions sparingly, and write your justifications liberally, right? So because that is going to be what is most important when it comes down to a dispute in front of the ICO. Now, lastly, and this is the last slide, Nigel, before we round off, we have what should you consider when you're providing a reply to the request? So the first thing to consider is the data in an easily accessible format. Generally speaking, the default is to reply in the same format in which the request was received. But in the event that you receive a request, via paper, by written letter, it might be legitimate to ask just to clarify, if it might be more appropriate to give them that electronically. There are a variety of reasons for that in terms of ease, accessibility, the environment, and so on and so forth. But also ask if there's any factor that prompts you to be aware of the fact that the person might have some accessibility issues. Might be also helpful to ask what reasonable adjustments you can make. It might be something as simple as providing the PDFs in larger fonts so that it's easier to read, and so on and so forth. The key thing is to ensure that you are cooperating and helping out the person as much as possible. And then lastly, transfer the data securely. So we've seen some very terrible examples of this. And without giving examples, what I can say is make sure that you are transferring the data to the data subject in a way that is secure and that ensures that only the person who is entitled to access the data will be able to access it. So we've seen this in a number of ways. So you can email it to them. That's the obvious one. You can upload it to a cloud storage, compliant cloud storage service, and then share a password with them to access it. So whatever approach you take, the goal is to ensure that they can only, they will be the only persons who can access that data. And lastly, update your log. This is important for the purpose of showing accountability to the ICO and also for your own audit trail in the event that you want to assess how well you've done with SARs, improve your processes, and ensure that you can, avoid any sort of exposure or liability going forward. The next slide, please. So yes, we do have a data subject access request training session coming up. It's coming up next month on the 22nd. It takes place over the course of a day, a full day. And we have a discount for persons who have attended this. We hope that you've had some insights from this, but just as a bonus, we also have a 20% off discount if you come through this course for that particular training session. So you can find the details.
What extra will I get out of that than if I sign up for that course?
What extras? So we have resources as well in terms of things that you'll be able to use for your organization, and access to some documents as well that will be helpful, I believe. And again, in that particular course, most importantly, you would have a deep dive into what you have to release and what you may not release. And I think that ultimately is the most important thing, because then you are able to get a full understanding of the exemptions and how to apply them, because that's most important. You don't want to make a mistake applying an exemption.
Okay. So ultimately, long term, it's a money saver. Yeah. And so to benefit the learners is that you acquire new knowledge, and it's a money saver long term, because you're not spending so long on subject access requests. Yeah, fantastic. Good.
Next slide, please.
Cool.
Yes, so this is about DPAS and the organization, as well as the other services that we provide. So our name is Data Privacy Advisory Service, and ultimately, first is we will provide a service as a DPO as a service, your external DPO, where you benefit from unbiased and objective expert advice. And that's important because a lot of times there can be situations whereby, because you're internal within the organization, there can be certain tensions that prevent objective information from being provided. We have no such factors limiting us, so you can be sure of getting exact, accurate, and unbiased objective advice for any instance. So if you need to create your organization's ROPA to comply with Article 25, if you need to conduct an audit to identify any areas where you need to make improvements, if you need to create policies, including the ones we discussed today, if you need help with SARs, we can also provide assistance with, collating, redacting your subject access request to ensure that you're providing the information in due time and without violating any of the laws in terms of not providing information you should be providing or providing information you should not be providing. So if you have needs with your website as well, cookies, your privacy notices internally and externally, please feel free to reach out via the email that's on screen. That's info@dataprivacyadvisory.com. We're going to be sending a survey, so that will be an opportunity as well to respond if you want to explore any of these services. Can we have the next slide, please? I think Nigel is going to speak about.
So thanks very much, everyone, for coming along. I hope we find it informative and helpful. And certainly, please don't be scared of subject access requests. always start from the point they are not absolute. So whilst you might have Mr. or Mrs. Angry shouting at you saying, I want all my personal information, I'm going to tie you up with a lot of crime, then that's not going to be the case. So that's the first learning point. It's not absolute. Second is have a dialogue with the data subject. Have a dialogue with the data subject. 3, justify everything you do, even if you use an exemption or only take part in a half search. Justify it. Kunbi quite rightly said, Article 5.2 said you have to demonstrate compliance, justify it. And 4, think of this as providing your fundamental human right. If you were an employee, what would you want out of a subject access question? Think of that. One last thought is that for those people who want to know things further, we're hopefully, it's hopefully going to be free on Wednesday, the 1st of February, 2023. We're holding in Bristol, the first Southwest Data Protection and Information Governance Conference. I'll be speaking there. Ralph O'Brien, who you may know, Barry Moult, who was Superman of the Year, IPO Superman of the Year, 2019, I believe. We've got some great stuff on surveillance. We've got a cyber escape room exercise going on. We've got some software demonstrations, and we've also got 2 professional, hopefully international athletes joining us to be able to talk about embedding data protection culture. Those tickets will be up for grabs towards hopefully by the end of the week when we confirm the venue. I'm hoping to keep that free, a free event that will be based in Bristol, and that will be an exciting event. So watch out for those. They'll be either on the DPAS LinkedIn or the DPAS website. They'll be out as well. We'd love to see you along. My job, quite simply, is to try and impart as much knowledge as I can around the tricky area of subject access requests to you all. I hope you found it useful. Kunbi, that was absolutely brilliant. Thank you very much for being my pal today and stepping in at the last moment.
Thank you all very much.
Thank you.
Thank you.